ऑनलाइन रिकॉर्ड रिकॉर्ड ऑनलाइन അറിയുന്ന So, good morning. All of you all are sitting the April exam, right? That's why some of the faces are not familiar. I know why some of you are here for the first time. So, I am disappointed that you were not here before, but I will not let you be disappointed by coming today, because I will basically give you a guideline on what your criminal procedure paper would be like. So I'm happy to see some of the familiar faces who came for my lectures in the last few weeks. Those people would have a distinct advantage over you, but well, it's your own seeking. But let me at the outset say what I really expect from you, and what you should also know. If you follow the instructions, criminal procedure, you will be able to score more marks than the other papers. In fact, I think most of you can score 60 marks at least if you follow what I tell you to the word. And that is the advisable thing for you to do, because I am not one of the lecturers who will mislead you. I will try to guide you as much as possible, but you have to be intelligent enough to know what I expect of you and to follow it. Right? So number one rule, I told in my lectures, those of you who thought it would be worthwhile coming for the lectures would have known had they come for my very first lecture. I insist on knowing the section. This is a procedural law. This is a very practical subject. If you don't write the section, I have told the examiners not to give you any marks, even if you have explained the principle properly. But despite my saying so, some of the examiners are more humane than me, so they give you marks. But the rule is, if you don't cite the correct law, when I say the correct law, it has to be the correct section in the correct law. If you write in the criminal procedure paper, section 23 of the civil procedure code, that is a wrong answer. So I don't want, and that shows your ignorance, right? We are not here to test the knowledge of the examiners or my knowledge. We are here to test your knowledge. If you can't remember the section and the subject under which you are writing, I will of course would have given very gladly 0 points. So write the correct section. If you are writing about bail, see whether it's the Bail Act provision that is there. If you write section 21 of the Criminal Procedure Code in the Bail Act answer for anticipatory bail, that is a wrong answer. You don't know the law, right? So number one rule, state the section very clearly. If you state the section, even if you fail in describing what is written word to word, that will not be a problem. As long as a section is right, you will probably get full marks or most of the marks. So state the section. If you don't state the section properly in any answer, almost in every answer, you are expected to give a reason for your answer. This is not a test for laymen. This is for third year law students who are going to be professionals. So this is a very practical paper, right? There won't be any theoretical questions. There is only one theoretical question in the paper, and that is also not a easy theoretical question, because this is, you are going to be practicing in 6 months if you pass this exam. So we want high standards here, and often law college, the standards are, most of the time what people tell us is the standards are not good enough. So I want to change that. So number one rule, section has to be stated. Then the good side of this is that this paper that I have made will be very easy for a person who knows all the sections. Such person who knows the sections and the relevant things and who follows my guidelines today would be able to even finish the paper in 1.5 hours. It's like that. If you write the answers precisely, you will get full marks. And for every answer, the marks you are getting is given in the exam paper itself. So you must know how much to write or how little you need to write. Right. So that is another thing that you have to remember. I will say this in Sinhala as well because I know still a majority of people are writing in Sinhala medium. ප්‍රශ්න පත්‍ර උත්තර දෙනකොට පළවෙනි නීතිය තමයි අදාළ නීතියේ වගන්තිය සහ නීතියේ නිවැරදි වගන්තිය සඳහන් කරන්න ඕන. එහිදී මම කිව්වා වගේ බේල් ඇක්ට් එකේ අපපනතේ 4 වගන්තිය 5 වගන්තිය සඳහන් කළ යුතු එකට කවුරු හරි අපරාධ නඩු විධාන සංග්‍රහය 4 වගන්තිය යටතේ කියලා සඳහන් කරොත් ඒ උත්තරේ වැරදි. මම නම් මේ ප්‍රශ්න පත්‍රය බලන්නේ මම ඒකට බිඳුවක් දෙනවා. ඕගලන්ගේ වාසනාවට සමහර එක්සැමිනර්ස්ලා මන් තරම් දරුණු නෑ. මේ ඒගොල්ලන් සමහර අවස්ථාවලදී ලකුණු දෙයි. නමුත් අතක තියාගන්න සෙක්ෂන් එක ලිව්වේ නැත්නම් නම් ලකුණු බලාපොරොත්තු වෙන්න බෑ. මම ඒක පැහැදිලිවම කියලා තියෙනවා එක්සැමිනර්ස්ලාට මේ අවුරුද්දේ ඒක තවත් දුරටත් මේව කරයි. ඉතින් සෙක්ෂන් එක පාඩම් කරන්න බැරි නම් කාට හරි එක්සෑම් එක නොලිය ඉන්න එක වැඩිය හොඳයි. එතකොට දෙවෙනි කරුණ තමයි අහලා තියෙන ප්‍රශ්නෙට අදාළ පිළිතුර අර කිරි ගහට යන්න වගේ තියෙන්න ඕන. එහෙම තිබ්බොත් ඔයාට පැය භාගයක් පැය එකමාරක් ඇතුළත මේ පේපර් එක අනිවාර්යෙන් ලියන්න පුළුවන්. Right. Then moving on, I will be telling you today the areas that are coming for your exam paper. And there will be a further discussion by DSG Lakmali Giriyagama also with regard to some of the areas that she has, because what we have done is actually she has made 2 questions in the paper. I have made the 7 questions. So she will have also a revision lecture where she will discuss the 2 questions that she has done and any other questions that might arise in detail, right? So I have done 7 questions, including the compulsory question. So I will be briefing you today on the areas that I have done and the areas on which you will be questioned. So don't ask me after the end of the lecture from areas which I have not discussed, because that means those areas are not coming. For example, we are not going to repeat any of the questions that we asked in the last October paper, because this is a repeat paper. And we are going to touch on areas which we did not basically touch in the last October paper. So anyway, that is not a rule, so to speak, because there are certain areas you have to anyway repeat. But we have tried to avoid that because we have been asked to also not repeat questions. Anyway, subject to all that, what we will have to do is, what I will do is, I will discuss the areas. So, for example, if I don't discuss anything about jury trials today, that means jury trials will not be asked. There will be no questions on jury trials for your paper in April. So, you don't need to really study about that area. You can focus on the other areas where I have highlighted. Right, so that's the general introduction. So how many of you all are external students? Can you all put the hand up? Okay. Right. Yours external. Okay. Right. So All those people, it's not required to attend the lectures. But that is not an excuse. If you want to really learn something, you must know that you have to come for the lectures, right? So the people who came for my lectures would understand that I am in the habit of discussing certain things when I'm discussing a topic. The examples I give, sometimes you would know, sometimes end up in questions in the criminal procedure paper. So people who don't come for class or don't bother to listen to me and only decide to come today will not have any benefit of that aspect, right? But subject to that, let's discuss what is coming this time, right? Uh, Now a very important area that on the last occasion that we did not question students was with regard to first information and statements made in the course of an investigation. So I'm referring to section 109 and 110 of the procedure code. You must know these sections thoroughly, right? Because they are so important. අපි මුල් තොරතුරක් ගැන සහ අපරාධ විමර්ශනයකදී අතරතුර කරන ලද ප්‍රකාශ එනම් පොලිසියට කරන ලද ප්‍රකාශවල නෛතික වැදගත්කම ගැන අනිවාර්යෙන් නීතිඥවරු හැටියට දැනගෙන සිටිය යුතුයි. ගිය වාරේ තිබිච්ච ප්‍රශ්න පත්‍රයේ ඒ ගැන අපි ප්‍රමාණවත් ප්‍රශ්න ඇසීමක් කරේ නැහැ. ඒ නිසා මේ පාර ඒ සම්බන්ධයෙන් විශේෂයෙන්ම ප්‍රශ්න තිබිය හැකියි. ඉතින් ඒ නිසා මුල් තොරතුරක් කියන්නේ මොකද්ද? විමර්ශනයක් අතරතුර සටහන් කරගන්න තොරතුරක් කියන්නේ මොකද්ද කියන කරුණ ගැන අවධානය යොමු කළ යුතුයි. 109 සහ 110 වගන්ති හොඳට දැනන් ඉන්න ඕනේ. ඒ වගන්ති වල සඳහන් දේවල් මොනවද කියන එකත් මුල් තොරතුරක් සපයන්න පුළුවන් කොහොමද? මුල් තොරතුරක් කියන්නේ මොකද්ද? කවුද මුල් තොරතුරු සපයන්නේ? මුල් තොරතුරක් තොරතුරු පොතේ සටහන් කරගත යුතු බව ඒ වගේ කරුණු අපි නීතිඥවරු හැටියට දැනගෙන ඉන්න ඕනේ. මොකද අපි අපේ සේවය නිසි ආකාරව ලබා දෙන්න නම් ඒ ගැන අනිවාර්යයෙන්ම හොඳ දැනීමක් තියෙන්න ඕනේ. So we need to know about what is a first information, how a first information should be recorded, where it is recorded, like the information book. Then with regard to the procedure of recording statements, when a police officer has to record a witness's statement, which is recorded in the course of an investigation. Those are things that you really need to know. Then under section 110, subsection 3, it's a very important section. You must mention the subsection as well. 110.1, subsection 1 deals with recording statements and how it should be recorded. But 110 subsection 3 and 110 subsection 4 deal with what are the practical uses we can make out of a police statement. All of us know that a police statement cannot be evidence. But we are now discussing about the exceptions to that rule. What can we do? And if you read 110 subsection 3, there is a proviso that says, according to 110.3, subject to the provisions of the evidence ordinance, a police statement can be made use of. So one of the best examples of how a police statement can be used is found in section 27 of the evidence ordinance, right? So if you are asked about a section 27 statement, how is the police statement used for that? You should be able to explain, and I'm not asking you to cite evidence ordinance provisions. That is a different subject. You will not be asked about single provision about the evidence ordinance. So you will be asked what are the provisions in the criminal procedure code with regard to marking a section 27 statement probable, or how a statement can be used to charge a person under section 180 of the penal code. Those are the uses that are there among other uses. So you need to know under 110.3 how a police statement statement made by a witness which does not amount to a first information can be made use of in a trial. Then discussing further, one of the main topics I discuss is with regard to arrest. And I discussed this subject very extensively, but with regard to arrest, the number of sections involved are very few. Remember always, if you are asked about under what provision of the law an arrest is made, what would be your answer? Tell me now, you all should have studied to some extent. That's a very simple question. Under what provision of the law is a legal arrest? At the back, please say out loud. As lawyers, you must know to speak up. In 6 months, you will be lawyers. Sorry? 23. 23 is correct, but I was looking for another provision, which even supersedes 23. Article 13(1). Very good. Because it is the, as you know, Constitution is a most supreme law. Constitution of our country is a supreme law. And if there is a constitutional provision about arrest and you don't mention about it, then that would be a big fault in the either with regard to the teacher or with regard to the student. So Article 13(1) should be referred to, because what does 13(1) say? It's a very simple article. It says that arrest must be done according to procedure established by law. I mean, it's not even difficult to by heart that. Arrest should be done according to the procedure established by law, and it also says the reason for the arrest must be stated. So that's the constitutional provision. Article 13(1), if it is violated, then that a legal arrest has not taken place. Then as your colleague answered, section 23 is the next most important section on arrest, where it is stated how an arrest should be made. If a person does not agree and come with you, you can physically touch that person, confine that person, and take him to your custody. Right? And remember again, reason for the arrest is something that you must state. If you don't state that, your answer is incomplete. You might get only half marks. Right? And there is a very important case with regard to reasons for the arrest, Correa versus the case of Correa. That should be cited if you are given time for your answer to be complete. Correa versus Queen. And what I forgot to mention at the start is, case law is not all that important, but if I have referred to a particular case law during my lecture and told you that that case law is an important case law, then you must take note of that. And in the answer where that case law has application, you must cite the correct case law. And some of you are in the habit of trying to bluff by writing about cases that are really not even in existence, right? The parties are totally wrong to that point. So don't try that. That might even reduce your marks. I have in my marking scheme told the examiners that citing case law is only secondary importance. Primary importance is the section. But if you cite a wrong case law, you are trying to mislead the examiners. You don't deserve to get any marks. If you don't know the parties, at least be honest about it and say, in a reported case, it was decided like that. And that would be fine. Right? So if you forget about Correa versus Queen, you can probably say, in a reported case, it was discussed that the reasons for the arrest is a mandatory requirement for an arrest to be lawful, right? So then again, talking about arrest, as I started in the lecture itself, you must know the meaning of what is a cognizable offense and what is a non-cognizable offense. Why is that important? Can somebody tell me what is a cognizable offense? දැන් මේ අත්අඩංගුවට ගැනීමක් ගැන නීතිය කතා කරද්දී අපි ආණ්ඩු ක්‍රම ව්‍යවස්ථාවේ 13 අනුව්‍යවස්ථා අංක 1 ගැන අනිවාර්යෙන් සඳහන් කළ යුතුයි. එයට අමතරව 23 වගන්තිය ගැන සඳහන් කළ යුතුයි. එහෙම සඳහන් කරනකොට අත්අඩංගුවට ගැනීමට හේතු දැක්වීම අනිවාර්ය බව මතක තියාගන්න ඕනේ. ඒ වගේම කොරයා එරෙහිව රැජින කියන නඩුව ඒ සම්බන්ධයෙන් පිළිතුරක් ලියනකොට උපයෝගී කරගන්න පුළුවන් සම්පූර්ණ ලකුණු ගන්න බලාපොරොත්තු වෙනවා. Right. Yeah, what is it? You had a question? Yeah. Okay. Tell me, what is a cognizable offense? Yeah. Column 3, yes. Yes. No, but that is, you are telling me where cognizable offense is given. You are not giving me the definition of a cognizable offense. What I am asking is there is a definition in the criminal procedure code about cognizable offense, which you have to know. Otherwise, you cannot pass this exam. Sanjay Varada කියන එක දන්නවද? Right. What is it? Where a peace officer can arrest without a warrant. Otherwise, in all the other offences which are called non-cognizable, Sanjay Novana Veradi, peace officer has to get a warrant to arrest. Either the peace officer or even if a civilian is arresting a person with a warrant, because the warrant is a judicial order, there is no issue. It is in cases where people arrest without warrants that there are issues with regard to whether the arrest is legal or not. So that is why it's important that you understand the distinction between cognizable and non-cognizable offences. Then under section 32 subsection 1, there are several instances given where a peace officer can arrest without a warrant. So if any situation falls within 32 subsection 1, then a peace officer can arrest without a warrant, and you must know those things to apply that situation to any given set of facts that are given in a probably a question, right? For instance, you know that if there is an army deserter and the peace officer knows that this person is an army deserter or a deserter from the forces, that person can be arrested without a warrant. Likewise, if there is anybody against whom there is a reasonable suspicion, a credible complaint or credible information, all those things are covered in a warrant. Covered under 32(1), where a peace officer can arrest without a warrant. So, Article 13(1), 23, 32(1)(b) are essentially 32(1). All the instances are essentially areas that you need to focus on, because that kind of answer is not difficult to give, and the explanation you have to write is also very simple. But if those provisions under 13(1) and 23 are not followed, the arrest becomes illegal. So that is why we as lawyers have to know that, and we discussed that one of the remedies for a wrongful arrest would be fundamental right jurisdiction in addition to civil action. Then also when we are discussing about arrest, we discussed about what is called a citizen's arrest. So you must understand under section 35 of the procedure code what a citizen In what instances can a citizen or a private person arrest a person? And once the person is arrested, in what type of cases can he arrest them? And once that person is arrested, what are the immediate steps that he needs to take? So we discussed this at length. So there could be a question about that. You must know the limitations of that, and you must know to quote the correct section and state about citizen's arrest. Then we also discussed about section 24 and 25. So people who came for this year's lectures also, I emphasized on this area. So people who came for my lecture this year would benefit from that, right? 24 and 25, I discussed at length with Anura Bandaranayaka's case as well. But Anura Bandaranayaka's case is not the ideal case to cite for that. But anyway, the case of Tangkamma we discussed, and I said why it's important. Under 24, when a person is acting without a warrant or with a warrant to arrest a person, and the person to be arrested goes into a house or a building and tries to hide there, the person arresting that person can go after that person and ask the householder to permit him free ingress to enter that building. 24 සහ 25 වගන්තිවල යම් තැනැත්තෙකු වරෙන්තුවක් ඇතුව හෝ නැතුව අත්අඩංගුවට ගැනීමට යන පුද්ගලයෙකු ඒ අත්අඩංගුවට ගනු ලබන පුද්ගලයා යම් ගොඩනැගිල්ලකට ඇතුල් වෙලා තියෙනවා නම් ඒ ගොඩනැගිල්ලට ඇතුල් වීමට ඔහුට අවසර ලබා දෙන්න ලෙස ඉල්ලා සිටියාම ඒ අයිතිකරු අවසර ලබා දීමක් කළ යුතු බව 24 වගන්තිය කියනවා. එසේ අවසර ලබා දීමක් නොකළහොත් හෝ යම් හේයකින් මේ දොර අර ගන්න විදියක් නැත්තම් එතකොට විකල්පයකුත් 25 වගන්තිය සඳහන් කරනවා. 25 වගන්තිය කියනවා එම නිවසේ බාහිර දොරවල් හෝ ජනෙල් කඩලා ඒ අත්අඩංගුවට ගැනීම සිදු කිරීමට පොලිසියට හෝ යම් වරෙන්තුවක් හෝ වරෙන්තුවක් නැතුව කටයුතු කරන පුද්ගලයෙකුට නීතියේ ප්‍රතිපාදන ලබා දීලා තියෙනවා කියන එක මතක තියාගන්න ඕනේ. අපි අර තංගම්මා කියන නඩුවේදී තංගම්මා හරිව ස්ථානාධිපති පේදුරු තුඩුව ඒ නඩුවේ කියා සිටියා ගයකට ඇතුල් වෙනකොට ගයකට කඩා ඇතුල් වීමට බලය දීලා තිනකොට වහලෙන් ඇතුල් වෙන්න බෑ. ඒගොල්ලන් ඒ තංගම්මා නඩුවේ කරේ වහලෙන් උළු ගලවලා ඇතුල් වුණා දොරවල් කඩන්න නැතුව. ඉතින් ඒක නීති විරෝධී කියලා අධිකරණය කිව්වා ගොඩක් පැරණි නඩුවක්. නමුත් දොරවල් ජඩේල් කඩලා ඇතුල් වීම නීති විරෝධී නෑ. ඒක ගෙවල් බිඳීමක් වෙන්නේ නෑ. So like in Tangamma's case, it was stated that you can't enter through the roof to a house, but under section 25, you have every right to break any external door or window and break into the house for the purpose of arresting a person. So if you go to abandoned house or which is locked, you have the right to break in. If there is no response to your knock on the door, you can break in after a reasonable amount of time. And so those provisions should be known to you because you might be questioned on that. Then with regard to other investigative provisions, we know that a magistrate gets involved in investigations and you can get certain orders from the magistrate. So with regard to the orders from the magistrate that you can ask, investigators can ask, sections 122, 123 and 124 are very important. But you might be asked a particular question where the answer is 123 subsection 1 If you write the answer 123 subsection 3, that is the wrong answer, right? Sometimes the examiners might not give you marks. So that's why these provisions, each of the sub provisions also you must remember the down to the subsection, right? If you, instead of 123, if you write 173, you can't expect full marks at all. You can't expect any marks for that matter because you're cited the wrong section. But if you cite 123.1 instead of the answer 123.2, examiners might be a little sympathetic because you have got at least 90% of the answer is correct, right? But try to write the accurate answer. As I told you earlier, the answer should be to the point, and that will not waste your time in writing the answer as well. So if you are asked about a situation where, for example, let's say there is a drunken driver who is arrested. I'm not going to ask this particular question, right? But I'm just giving you a type of question that might come. I have not asked this question, obviously. I'm not going to leak the paper like that. But let's say there is a drunken driver and the police have no breathalyzer kits. Only way that they can find is by getting that person to undergo a blood test. And you know, if the police come and ask you to give a blood test, you can refuse if you don't want to. Then what can a police officer then do? Police officer will have to then go to the magistrate and get an order. And that type of thing can happen under 122, the particular subsection, or 123. Then 123 speaks about such instances with regard to fingerprints, handwriting samples, and things like that. Where if two people are arrested, one person might consent to the fingerprints being taken so that they can be compared with the fingerprints found at the scene of a crime. So if the person consents, then the police officer is acting under 123 subsection 1. But let's say the other suspect who is arrested, he does not consent. So then the police officer has to go under 123 subsection 2 and get an order from the magistrate to have the fingerprint samples given on a court order. So likewise, handwriting samples also can be taken like this. And then you must know under what legal provision an identification parade can be applied for. All of us know that there are no laws which give guidelines with regard to how an identification parade should be conducted. That is governed by the judge's handbook, judicial officer's handbook that is given to the judges. That gives a guideline. But with regard to applying for an identification parade, which is often done in criminal cases where the suspects are not known, witnesses have to produce themselves before an identification parade. So that is under section 124. So you must know that section because that's a very important section where the magistrate gets involved with regard to holding an identification parade. Then now I know from experience when I ask questions about identification parades, students really love that topic and they really become a nuisance to the marking examiners because whatever question I ask about the identification parade, they have a set note that they sort of reproduce, right? So I don't want you all to be like that. You all are not tape machines or I don't know how else to describe it. But so really vomiting back what is put into your stomach is not the idea that is expected of a lawyer. You must know to apply the correct principles. So I'm not going to ask you about how an identification parade is conducted. Then if I ask that question, you normally write about 4 or 5 pages of it. And the answer is somewhere in that 4 or 5 pages, you will find the answer also. But that is not the correct thing. That shows that you know something about identification parades, but you are unable to answer the specific question. So this time I will ask very particular questions about identification parades, particular steps that a magistrate has to make, and you will have to give an answer for that. So when an identification parade is to be held, you know one of the most important thing is that the witnesses and the suspects have to be separated. And when the suspects are brought, how they are brought into the identification parade is very important. You know that they have to be brought in covered from head to toe. හිසේ සිට පාදාන්තය දක්වා ආවරණය කරලා තමයි හඳුනා ගැනීමේ පෙරටුවකට සැකකරුවන් ගේන්න ඕන. ඒ ගේනකොට ගත යුතු පියවර ගැන අනිවාර්යයෙන්ම ඕනෙම මහේස්ත්‍රාත්වරයෙකු මෙන්ම නීතිඥවරයෙකුත් දැන සිටිය යුතුයි. Then with regard to the ratio of people in a parade, there are a lot of case laws where Pereira versus State is one of the cases where we discussed about several prison officers standing in line. That identification parade had about 55 persons altogether. 55 persons in identification parade, which is a very bad state of affairs. The ideal ratio is 1 to 6. 1 to 6 ratio. So that was held in this Pereira's case, and in that case it was also stated ideal situation is to have separate identification parades consisting of 7 people with regard to each of the suspects. But of course, if there are 1 or 2 suspects, the magistrate can have one identification parade because it makes the magistrate's life easier. Because altogether there will be only about 14 people, including the 2 suspects in that parade. හඳුනා ගැනීමේ පෙරට්ටුවලදී කී දෙනෙක් ඉන්න ඕනේද කියන එක. 1:6 අනුපාතයට තමයි ඉන්නේ. ඒ කියන්නේ එක සැකකරුවෙකුට පිටස්තර පුද්ගලයන් 6 දෙනෙක් පෙරට්ටුවේ හිට ගැනීමට අවස්ථාව තියෙනවා. ඒ වගේම පෙරට්ටුවේ හිට ගන්න අයට සැකකරුවන්ට ඒ ස්ථානය ඔවුන් හිට ගන්න ස්ථානය මහේස්ත්‍රාත්තුමාට නිර්දේශ කරන්න බෑ. මහේස්ත්‍රාත්තුමා ඒකේ අභිමතය සැකකරුවන්ට දෙන්න ඕන. සැකකරුවෙකුට අයිතිය තියෙනවා ඕනෙම තැනක පෙරට්ටුවේ පළවෙනි තැන ඉන්නවද නැත්නම් 7 වෙනි ස්ථානයේ ඉන්නවද 4 වෙනි ස්ථානයේ ඉන්නවද කියන එක තීරණය කරන්න මහේස්ත්‍රාත්තුමා නෙමේ ඒ පෙරට්ටුවට සහභාගී වෙන සැකකරු. ඒ වගේම සැකකරුගේ හිසකෙස් වල මේ හිස පීරන ආකාරය ඔහු ඇමගින්න ඇඳුම් ආදී දේවල් මාරු කරන්න පුළුවන්. So the discretion should be given to the suspect on where he stands in the ID parade and what type of clothes he can wear. He can change his appearance by combing his hair backwards or in a different way than he normally combs. So things like that are permitted in identification parade because it is necessary that the identification is done conclusively. And to make the identification difficult for the witness is the best way. Right? Then now in the identification parade, you must remember that when a witness is brought, the suspects are brought from one side, witnesses are kept in another side of the building, and they are brought in one witness at a time before the parade. And witnesses have to identify these people normally by walking in front of the people in a parade. But later on, from an amendment, it was permitted for the witnesses to identify people from a enclosed area where the witness is not seen to the parade. So that also is possible. That is something that the witnesses can ask from the magistrate, and the magistrate can permit it. Then further, before a suspect is at the identification parade, before a person is identified, you cannot, the magistrate cannot ask any question from the witnesses about how they identify these people. Once a person is correctly identified only, the magistrate needs to ask questions about how did he identify this particular suspect. So that was decided in the case of Joseph Aloysius, which case law you can cite if there is a question to that effect. So Joseph Aloysius case, Pereira versus State with regard to the proportion are two cases that may be important for you to remember. Don't cite any other cases, you are not going to get any marks, right? I know you all get notes from various people. Some of my notes are also violating all copyright norms, circulated and sold at various shops, I know. So I can't prevent that because I'm trying to give my note to the genuine students. But the crap that they give you, I'm not bound to give marks for. So I'm not going to, if you write a wrong answer, and I have seen this answer in the notes, in the Sinhala text, most of the people write, හඳුනා ගැනීමේ පෙරටුවට පෙර පුද්ගලයන් රඳවා සිටින ස්ථානයේ පුද්ගලයන්ගේ පවුලයට බලන්න පුළුවන් අනිත් අයට බලන්න බෑ කියලා. මම කවදාකවත් පවුලයට බැලීම ගැන වචනයක්වත් කියලා නැහැ මගේ එකම දේශනාවකවත්. ඉතින් ඒවා මම දන්නවා එන්නේ කෙලින්ම ඔය කොහෙන් හරි ටියුෂන් කඩවලින් එන දේවල්. ඒවට නම් ලකුණු බලාපොරොත්තු වෙන්න එපා. මට නම් සමහරවිට තරහටත් එක්ක මම ලකුණු දෙන එකක් නැහැ. ඒ වගේ මෝඩ ප්‍රශ්න වලට උත්තර ලිව්වොත්. ඒකයි මම මේ අවස්ථාවේ පැහැදිලිවම කියන්නේ. සිංහල මේ සටහන් වල තමයි ඒක තියෙන්නේ ගොඩක්. ඉංග්‍රීසි මේවල මේ උත්තර පිළිතුරු පත්‍ර වල ඒක මම දැකලම නැහැ. සිංහල පත්‍ර වල නම් ගොඩක් අය ඒ සටහන් මම දන්නේ කවුරු ගහන සටහනක්ද කියලා. මගේ සටහන ආශ්‍රිතව තමයි ගහන්නේ. නමුත් ඒගොල්ලන්ගේ වැඩි හොඳ පෙන්වන්න අනවශ්‍ය නඩු තීන්දුව නීති නඩු තීන්දුව සටහන් කරන සමහර නඩු තීන්දුව අදාළත්වයකුත් නැහැ. So don't waste your time by writing inconsequential and unnecessary responses to answers that you have been asked particularly. Just answer the question that I have asked. Don't waste your time writing unnecessary nonsense that is not even asked from you. Right, so then identification parades, you have to know the law. It's a very important section. And so those procedures, you have to know your basics. Then of course, in the last exam, I did not ask about the time period that a person can be kept in police custody without being produced before the magistrate. That is something that all lawyers should know. Under section 37, the 24-hour rule. Police can only keep a person in their custody for a maximum period. Minimum period is given in 36, but maximum period is 24 hours. And when you are writing this answer, if you just write 24 hours, you are not going to get full marks. You have to cite the section 37, right? Sorry? Yeah. So you can state in that is okay because that is there in the section. The period of 24 hours is excluding the period that the police will take to transport the suspect from the police station to the magistrate's court. So if that is normally you are producing the person before the magistrate's court within your police jurisdiction. So that will not even take normally in most cases less than 1 hour. Right? Because anybody arrested in probably somewhere like Modara will not be taken to the Nigambo magistrate. He will be taken to the Alsdorf magistrate's court. So that will not take more than 1 hour, even if you drive at 10 miles per hour, right? So that period you can mention. 24 hours is the maximum period anyway. Sorry? Yeah, that's a good thing you asked me that question. Now you don't need to write about the exception. Have I asked about exceptions here? If I have asked about the exceptions, then please do write. But if I have not asked about the exceptions, don't ask for. Because we know under special laws, there are special provisions. Under the Dangerous Drugs Ordinance, we can detain a person for long. Under the PTA, we can detain a person for longer. But I have not asked about them because I have not gone into detailed description of that. I have just mentioned that there are exceptions to any rule, right? So you don't need to, and you will find in that question, if there are only about 2 marks you are going to get. I'm not asking you to write all the exceptions because exceptions will take you another 5 or 6 minutes to just elaborate on, right? And you need to know the basics before you know the details about procedure. So let's stick to the basics now. Then under the Bail Act. So normally under the Bail Act, I have this famous question that I always ask about how you get bail in a murder case. So this time in all these years, I'm not going to ask that question because even some of the examiners told me, don't repeat that question. You have asked almost in every case. So that question will not be asked. So that is, I think, you all can heave a sign of relief because most of you all, even though I have asked in every exam, still there are people who get it wrong. Right? So this time the question I'm asking, chances of your getting wrong will be less. And you can wait without worrying. You don't have to find the answer to that particular question. But that doesn't mean that I'm not going to ask any important question on bail, right? And on bail, we must know the very fundamental thing. That is, it's not section 2. Most of the students think that section 2 is the most important section in the Bail Act because it says that bail is the rule and not granting bail is the exception. That may be a good thing for you to say when you are a practitioner, when you are making a bail application, very good. But you must know the basis on which you are going to get bail for a particular offense. So for that purpose, you must know the definition of bailable offense and non-bailable offense, right? Where do you find this definition? You find it in the Criminal Procedure Code as well as in the Bail Act. Criminal Procedure Code in section 2, you will find bailable offences and non-bailable offences. There are definitions. So you must know the definition very well so that you will then only be able to understand the nature and the place where you have to make applications with regard to bail. Then the next fundamental thing that you need to know with regard to bail is what is a bailable offense? What is a bailable offense? Bailable offense is an offense where under section 4 of the Bail Act, bail is granted as a rule. Bail is granted as a rule by a court. And court will, if the court refuses bail, court has to record reasons. Court has to record reasons if the bail is refused. So in other words, simply put, bail is there for you for a bailable offense for the asking. අපපනතේ 4 සහ 5 වගන්ති ගොඩක් වැදගත් වෙනවා. 4 වගන්තිය අප දිය හැකි වැරදි පිළිබඳ අදාළ වගන්තියයි. අප දිය හැකි වරදක් සම්බන්ධයෙන් අප ලබා ගැනීම අයිතිවාසිකමක් හැටියට ඉල්ලා සිටිය හැකියි. ඒ අනුව සාමාන්‍යයෙන් අප දිය හැකි වරදක් සම්බන්ධයෙන් යම් අධිකරණයක් විසින් අප ප්‍රතික්ෂේප කරනවා නම් ඒ සම්බන්ධයෙන් හේතු දැක්වීමක් අධිකරණය දිය යුතුයි. නැත්නම් අප ඉල්ලූ පළියටම අප ලබා දෙන්න සිද්ධ වෙනවා. ඒක තමයි අප දිය හැකි වරදක සහ අප දිය නොහැකි වරදක තියෙන වෙනස. දැන් අප දිය නොහැකි වරදක් කියලා අදහස් කරන්නේ මොකද්ද? ඒ කියන්නේ අර ගොඩක් අය මම අර ඉස්සලා කියපු ප්‍රශ්නේ මිනිමැරීම් නඩුවල මිනිමැරීම අප දිය නොහැකි වරදක් කිව්වහම අර මේ සාමාන්‍ය පිරවසියෙක් වගේ ඒගොල්ලන් හිතනවා අප ලබා ගන්න බෑ මිනිමැරීමේ නඩුවකට කියලා. ඒක නෙමෙයි අදහස. අප දිය නොහැකි වරද කියලා කියන්නේ අයිතිවාසිකමක් හැටියට අප ඉල්ලා සිටින්න බෑ. නමුත් අධිකරණයේ අභිමතය මත අප ලබා දිය හැකි වැරදි. Non-bailable offence is not that you can't ask for bail, but where a court will grant, there are offences which are of a more serious kind, where bail is granted only at the discretion of court. What is meant by discretion? Court has the power to grant or refuse bail. In either case, you have to give reasons, the court has to give reasons for the decision. So, obviously, it's difficult to get bail for a non-bailable offence because it is not as of right that you will be entitled to bail. And non-bailable offences are governed by Section 5 of the Bail Act. No. You or they don't give because under Section 5. Under Section 4, if you refuse to give bail only, you have to specifically state the reasons. If you give bail, you don't really need to give reasons. But under Section 5, since there is a discretion involved in non-bailable offences, you have to give reasons in either case, whether your bail is granted or not, right? Then, yes. Section 14 is also, Section 14 states about the possible reasons that bail can be granted. Now, the next area about the Bail Act that you need to know is with regard to the reasons. When you're talking about reasons for granting bail, what are the main reasons that a court will consider in granting bail? And that is given in Section 14 of the Bail Act. So Section 14 of the Bail Act, remember it says that not only in cases where bail should be granted in the first instance, but even in cases where bail has first been refused and later granted, the considerations that are there in Section 14 should be looked into. Then also, in a case where bail has been granted, later there is some violation of those Section 14 requirements. Section 14 permits the court to cancel bail, cancel the bail that is given. So for example, a very common example that happens is a person in a high court has been granted bail during the trial, but during the course of the trial, let's say one witness is approached, our main witness, let's say the main eyewitness, is threatened by somebody. Something like that. And that witness comes to the police and complains. The police will immediately bring it to the notice of the High Court judge or the magistrate who gave bail, and they can move under Section 14 of the Bail Act to cancel the order. When you are cancelling the order also, Section 15 requires that reasons should be given. So, a situation where a witness is interfered with is a situation where bail can be cancelled. And it should be like that also, right? Because otherwise you can't do justice in this system. If a witness is approached and threatened, we can't allow the accused to be on bail because he will continue to do that. And if the witness is actually tampered with, as we see in certain cases, entire case will collapse, especially if that's the only witness who is there to give evidence about the facts of the case. So Section 14 of the Bail Act is important. And then the concept of anticipatory bail. Anticipatory bail is under Section 21 of the Bail Act. So what is meant by anticipatory bail? You must be able to explain. And anticipatory bail is sought by a person before the arrest. It is sought by a person who thinks to himself that I will soon be made a suspect in this case. He's still not a suspect, but I will soon be made a suspect in this case. And therefore, before I'm arrested, I'm going to go before the court and get bail so that at the time of my arrest, I would be enlarged on certain conditions imposed by the court, right? And anticipatory bail, what you must in any answer for anticipatory bail, section 21 is the relevant section, 21 of the Bail Act, no other law, right? 21 of the Bail Act, anticipatory bail. What you must remember is it is for anticipatory bail can be sought only for non-bailable offences. Non-bailable offences. අපේක්ෂිත අප සම්බන්ධ අයදුම්පතක් ඉදිරිපත් කළ හැකි වන්නේ අපදිය නොහැකි වරදක් සම්බන්ධයෙන් පමණයි. ඒක මතක තියාගන්න. ඒක ඉතාමත් වැදගත්. අපදිය නොහැකි වරදක් සම්බන්ධයෙන් පමණයි අපේක්ෂිත අපයක් ඉල්ලා සිටීමට හැකියාව තියෙනවා. මොකද අපි දන්නවා අපදිය හැකි වැරදි වලට අයිතිවාසිකමක් හැටියට අප ගන්න පුළුවන්. ඉතින් ඒක පැහැදිලි. අපදිය හැකි වරදක් සම්බන්ධයෙන් අපේක්ෂිත අප කතාවක් නැහැ. අපේක්ෂිත අප තියෙන්නේ අපදිය නොහැකි වරදක් සම්බන්ධයෙන්. Yeah, I come to that. Yeah. We must also know where bail applications need to be made in which court. As I told you during the lecture, the rule is that most of the bail applications, when I say most, about 90% of the bail applications come up in the magistrate's court. Very few bail applications come up in the High Court. High Court bail applications are governed by section 13 of the Bail Act. Only with offences with regard to offences under section 13 of the Bail Act that applies, that bail can be taken from the High Court. All other offences, although there is no section to say that, all other offences that don't fall within section 13 of the Bail Act, the forum jurisdiction is the magistrate's court. All other bail acts. So, in the actual fact, what happens is, Bail Act section 13 says that if anybody is punished by death or life imprisonment, where the punishment is death or life imprisonment, only in those cases you have to go to the High Court to get bail. In all other cases, it will be in the magistrate's court. So there can be grave crimes like rape, robbery, attempted murder, where bail can be granted by the magistrate's court despite the severity of the offense. But where the punishment is death or life imprisonment, now offenses for that would be like murder, possession of more than 5 grams of heroin, then possession of automatic firearms and committing some offense using an automatic firearm. Those are offenses where the magistrate can't give bail because the sentence is life imprisonment, right? So only in cases of death and life imprisonment, you go to the High Court under section 13 of the Bail Act. In all other cases, bail has to be applied from the magistrate's court. And that is meant by forum jurisdiction. Forum jurisdiction is in which court? In which court you have to make that bail application. Then when we are talking about bail, and even with regard to conditional discharges, there is a term called antecedents. Antecedents. What do you mean by the term antecedents? Can somebody tell me? Nobody can tell me because none of you have come to my lecture. That's why. Antecedents I discussed at length during the last year. I haven't done that yet in this year. But what do you mean by antecedents? Sorry? Past behavior. Yes, you are somewhat correct, but it's not past behavior, it's actually past convictions. It's your previous convictions. What is meant by antecedent? Right? Purva kriya kalapya. Purva kriya kalapya කියලා අදහස් කරන්නේ පෙර වැරදි ගැන. ඒ අර්ථ දැක්වීම වැදගත් වෙනවා. මොකද අපි දන්නවා කොන්දේසි සහිත සමාවක් ගන්න අවස්ථාවක ඒ වගේම අභියාචනයක් පවතින අතරතුර අප ලබා ගැනීම සඳහා పూర్ව ක්‍රියාකලාපය බලපාන හේතුව මත. In cases where conditional discharges are applied for or sought, and in conditions where bail pending appeal is sought, antecedents of the suspect or the accused is something that the court will always consider as a material factor in deciding to grant bail or grant some other relief for that particular convict. So the meaning of antecedents is necessary to understand, and you should be able to define them. Then we have to, then we must know about section 29, that is with regard to productions. When a person is arrested, I discussed under section 29, the police have to take charge of the productions. They have to enter it into a book in the police and keep charge of those productions until the end of the trial. So section 29 you have to know. Then with regard to disposal of productions, you have to know about section 425 and 431 of the Procedure Code. Under 431, any person whose productions are in the custody of a court can ask for the productions to be released. If they are the owner of that productions, they can ask for those productions to be released to them on a bond subject to certain conditions. Let's take for example, if there is a robbery case and the productions in that robbery case were actually gold jewelry belonging to you. Say your wife's thali has been robbed in a particular robbery, and it's very important that you have the thali when you have a wedding. So if you want to get the custody of that thali, normally for it to be released to you completely, the case has to be concluded. But when it's a production in the case, it has been taken under section 29 from the suspect's custody, but you can ask for it from the court to be released to you on some condition. And that application is done under 431, where if a lawyer makes a correct application, the court will release that thali on some condition. Court will say, sign a bond that if you don't produce this thali on every trial day, you can keep the custody of the thali, but you have to produce it on every trial day so that we can show it to the witnesses in the course of the trial. And you can't sell the thali or dispose of that property until the conclusion of the trial. So on conditionally, under section 431, if an application is made, the person entitled or the owner of that property can be given temporary sort of custody of that property pending the trial. Then 425 deals with a situation where at the end of the trial, irrespective of whether the accused is convicted or acquitted, at the end of the trial, the person entitled to the ownership of that property will be given the property to them absolutely without any condition. So what you must know as a lawyer is when to make application under 431, when to make an application under 425, right? So if you get the two sections mixed up, you're not going to get any marks, but you have to say the correct sections for the correct situation. Yes, normally, even if there is no application made, sometimes the courts release the property. Normal question is, if you want to get something like a gold jewelry or something, court can court can actually have an inquiry and decide on who is entitled to the property and release it. Last time, yeah. So these are very fundamental aspects of dealing with property that are needed to be known in the uh, under the Criminal Procedure Code. Then also you must know situations where the police officers can search a premises. So a search warrant is obtained under section 68 of the Procedure Code, and under section 70, the powers of executing a search uh, is given under section 70 of the Procedure Code. So 68 and 70, you have to know uh, with regard to during the course of an investigation, if a particular premises is searched to gather evidence or proceeds of crime or something like that, or any document that needs to be produced, then search can be obtained on a court order. Search warrant is a court order that permits the investigating officer to visit a particular premises during certain times of the day for a time period and search the premises for any items that may be relevant to that investigation. Then we must know about a warrant. Warrant is also a very important aspect, and as I told in my lecture, at the very outset when people pass out as lawyers, one of the best modes of practice is for you will get cases of having to recall warrants against people who are suspects and witnesses. If a person does not appear in court, once the summons are issued, if a person does not appear in court, the most probable thing that would happen is for the court to issue a warrant on you. So when a warrant is issued, it is issued under section 50 of the Procedure Code. And when the warrant, according to section 50 subsection 2, the warrant will be in force until it is executed or it is recalled. So if the warrant is not recalled, it will be in force, right? And we spoke about a case called King versus Sinnadi. King versus Sinnadi, where a person who was arrested on a warrant was produced before the court and he was given a warning, but that lawyer forgot to ask for the warrant to be recalled. And when Sinnadi walked out of the court, he was rearrested by the police, taken into police custody once again. So that is wrong. A person who is produced before court on a warrant or against a person against whom a warrant has been issued, and when a lawyer surrenders that person, the lawyer must remember to make an application to recall the warrant. And once the warrant is recalled, the police can't rearrest him for that case, because the warrant ceases to be in operation when it is recalled under section 50 subsection 2. Right? Mahanama Tilakaratne's case is also somewhat important with regard to warrants. Then you must know how to make an application in court as a lawyer to recall a warrant. You must file a motion, get the case in which the warrant was issued, hauled in open court. Thereafter, you must produce the person against whom the warrant went out, and you must make an application referring to section 50, asking that the court recall the warrant that was issued by court. Right? So you must be able to make that application. You must be able to give an excuse for why your client did not come on the trial date. Say for some medical reason he was not well, or there was some accident at home, or some really urgent reason. then you must be able to produce a medical record or some kind of proof to that effect and ask the court to recall the warrant. And the court has the right, subject to whatever condition the court may think fit, to recall that warrant. But if you have not made that application to recall the warrant, you have made a very big mistake as a lawyer, because your client has written you not only to surrender him, but also to recall the warrant so that to prevent the police from re-arresting him. Then we have to know about joinder of charges. On the last occasion, I asked about sections 173 and 174. This time, I will not ask about those two sections, but you must know about the other sections of joinder. That leaves section 175 and 180, joinder of persons. When more than one person can be joined in one charge sheet, that is under section 180. And 175 subsection 1 deals with a situation where several offences of different kind are committed in the course of a same transaction. Then the joinder is under section 175(1). එකම ක්‍රියාකලාපයකදී අපරාධ ගණනාවක් කරලා තිබෙන අවස්ථාවක 175 එක වගන්තිය යටතේ චෝදනා එකට ගොනු කරන්න පුළුවන්. එකම අධිචෝදනා පත්‍රය හෝ චෝදනා පත්‍රයක ගොනු කිරීමේ හැකියාව තියෙනවා එකම ක්‍රියාකලාපය කියන පදනම මත. ඒ වගේම 180 වගන්තිය යටතේ චෝදිතයින් කිහිප දෙනෙක් එකම අධිචෝදනා පත්‍රයේ හෝ චෝදනා පත්‍රයක් යටතේ චෝදනා ගොනු කිරීමේ හැකියාව තියෙනවා. ඒ වගන්ති දෙක ඒ නිසා මේ පාර වැදගත් වෙන්න පුළුවන්. Then with regard to high court trials, you must know the importance of section 196, where the indictment is read. Then if a person is pleading to the indictment under 197, what is the position? How should that plea be recorded? මහාධිකරණ නඩු විභාගයක ආරම්භයේදී අපි දන්නවා 196 වගන්තිය යටතේ අධිචෝදනා පත්‍රය කියවලා දීලා වැරදි කරුද නිවැරදි කරුද කියන අහනවා. ඊට පස්සේ එම අවස්ථාවේ අපි කිව්වා ප්‍රතිචාර තුනක් තියෙනවා. වැරදි කරු කියන්න පුළුවන්, නිවැරදි කරු කියන්න පුළුවන්, නිශ්ශබ්ද වෙන්න පුළුවන්. එතකොට මේ අවස්ථාවවලදී ගත යුතු පියවර මොනවද කියන එක දැනන් ඉන්න ඕනේ. 197 වගන්තිය යටතේ වරද පිළිගැනීමක් කරනකොට ඒ වරද පිළිගැනීම සටහන් කරන්නේ කොහොමද කියන එකත් දැනන් ඉන්න අවශ්‍යයි. ඒ වගේම අධිචෝදනා පත්‍රයක් සමග ඇමිනිය යුතු දේවල් පිළිබඳව, what are the attachments to the indictment, needs to be specified. It is given in section 162(2), subsection 2. The attachments to the indictment should be known by you, so that you will be able to do any high court trial with that, knowing your rights. That should be the statements that should be given to you and the reports that should be given to you. Then we have to discuss about a very important topic again, about unlawful assemblies. It happens every day in Sri Lanka. Even last evening when I was going home, there was a protest in front of the Port railway station. That was ended with, I think, a lot of tear gas being used last evening. So unlawful assemblies are a very important way of life in Sri Lanka. So I'm going to ask you a question definitely on that. So we discussed about We discussed about unlawful assemblies, and the most important section is what? Can somebody tell me? Okay. Some of you came for my lecture, I think about 2 weeks ago, when we discussed unlawful assemblies. That's why I asked that question. Anyway, section 95 is the section that matters with regard to how an unlawful assembly should be dispersed, right? නීති විරෝධී රැස්වීමක් විසිරුවා හැරීම සම්බන්ධයෙන් වැදගත්ම වගන්තිය වන්නේ 95 වගන්තිය. 95 වගන්තියේ 95 උපවගන්ති 1 2 3 කියලා තියෙනවා. 1 2 3 වගන්ති 95 1 වගන්තියේ තියෙන්නේ නීති විරෝධී රැස්වීමක් විසිරුවා හැරින පළවෙනි පියවර. දෙවෙනි පියවර 95 2 තියෙනවා. තුන්වෙනි පියවර 95 3. ඉතින් මේ පියවර තුන පිළිවෙලින් විස්තර කරන්න හැකියාව තියෙන්න ඕනේ. හරි? ඒ පිළිවෙල වරද්ද ගත්තොත් උත්තරය නිවැරදි නෑ. So section 95(1) to 95 subsection 2, 95 subsection 3 gives how an unlawful assembly can be dispersed according to law. And that's the only provision in the entire criminal procedure code that dispersal of an unlawful assembly to be done legally is spoken of. Then there is a situation under section, no, so before that, if you are asked a question about dispersal of an unlawful assembly, all you need to write is only about 95(1), 2 and 3, but you must tell the procedure, how it works exactly. Who is authorized to do that? Officer above the rank of IP or a magistrate. Nobody else can ask to disperse an unlawful assembly, right? So remember those things. What is an unlawful assembly is described in section 138 of the Penal Code. There is no definition in the Criminal Procedure Code, so Penal Code definition of unlawful assembly would apply. Then there may be a situation, there is a situation of a dispersal of an unlawful assembly under section 96 as well. But in that situation, what is contemplated is when there is no police officer, when there is no police officer or magistrate, when there is no police officer or magistrate in the scene, and it's a very urgent situation where the unlawful assembly has to be quickly dispersed for the purpose of breaching national security, something that is very imminent and where you have no other choice but to resort to military action. In that type of situation, in a very exceptional situation, section 96 can allow a military officer to get involved in dispersing an unlawful assembly. So when a military officer gets involved in dispersing an unlawful assembly, he is entitled to use military force. But when you use military force and disperse the assembly, he must, if he arrests somebody, in the course of that, he must make it a priority to take those people who were arrested and hand them over to the relevant OIC or the police station closest to where the assembly took place. Right? So if the unlawful assembly has happened like it happened yesterday in the opposite the Fort police station, all the arrested people should be taken to the Fort police station, handed over to the Fort police. Remember, normally military officers can't get involved in dispersing unlawful assemblies. It is only in very exceptional situations. Even under 95 subsection 3, military strength can be made use of, but they are under the authority of the magistrate or the police officer. So study those provisions, and with regard to answers, the case of Bernard Soisa I spoke about, and the other case, IP Jagodarachi's case. Those two cases can be cited. I don't want you to cite any other case. Sorry, I can't. IP Jagodarachi's case, right? IP Jagodarachi, Bernard Soisa's case, where I discussed about the protest at the Mahamalua. I have given that in my note. So you may cite both those cases. Don't cite the case of Mahinda Rajapaksa, although you remember the name very well. That has no application to what I have thought. So cite the relevant cases that I have told. Other cases, citing them will not be of no value for you as in terms of marks. No, there is no. Because commission officer has to be in charge of his forces, so it has to be a commission officer for that purpose. But everybody, all the people need not be normal soldiers. Non-commissioned can also participate. Then we have to. Then there might be questions with regard to the non-summary procedure. Now another one of my favorite questions have been in all the papers, how a deposition is recorded under Act number 2 of 2013. This time I will not be asking that question. Anyway, the answers that you all write are always, for the most part, wrong. So you won't get any marks. So I thought this time I will not ask that question. Like that earlier, bail for murder cases. So this time I'm dropping that question, but I'm asking some other questions which might be necessary for you to remember. Now at the non-summary, I told you at the non-summary inquiry, which is not a trial, at the very beginning we read the charge sheet, but no response to the charge is recorded. That is under 148 of the procedure code. But at the end of the non-summary, where the charge sheet is read, I think it's under 150 or 51. Anyway, you have a look at that. At the end of the non-summary, when the charge sheet is read, there the accused is called upon to make a plea or make any comment. What it says is that if the magistrate thinks that there is a case made out against the accused, he can read out the charge to the accused. Now this is at the end of the non-summary. All the evidence has been recorded in the non-summary. And the accused knows very well whether that accused is strong or weak. Then the accused is read the charge sheet for the second time. At that point, what is recorded is very important. What the court will ask is, now you have been charged with this. This is the charge against you, that on such and such a day, at such and such a place, you have committed the murder of A. What do you have to say about that? So then the accused can say, I am not guilty. And most of the time, he will say that I am not guilty. But he can also say anything. But before his response is recorded, the magistrate can give him a warning. And he gives a warning saying that the charge is going to be read over to you. Whatever you say in response to the charge will be used as evidence against you in high court trial. So that subject to that warning, that person can make any comment. And whatever response he does to the charge is known as the statutory statement. Statutory statement. And statutory statement becomes very important under section 151. It is recorded by the magistrate and it can be used in your high court case against the accused. So for example, what happens if the accused says that he is guilty to the charge at the end of the non-summary evidence. Non-summary inquiry is not a trial, so you don't have to worry about it. But the fact that he pleaded guilty can be made use of him in his high court trial to show that he made an expression of guilt, and that would amount to a confession made to a judicial officer. So that would have a very high level of evidentiary weight. Right? On that alone, sometimes he might be even convicted in the High Court. It's so important, right? So you must know about the provisions for statutory, with regard to recording a statutory statement, at which point in the non-summary inquiry it is recorded, and in the High Court trial, at what point it is utilized. In the High Court trial, it is under section 199 subsection 3. 199 subsection 3. In the High Court trial, what he said in the magistrate's court can be put in evidence by the prosecution. And it's a very important aspect. Right? Then going back to the non-summary procedure, we know at the end of the non-summary, there are two possible orders that the magistrate can make. One order is the committal of the case to the High Court. That is when the magistrate is of the view that there is sufficient evidence found at the end of the non-summary inquiry. The case is committed to the High Court by the magistrate, and that is done under section 154 of the Criminal Procedure Code. The second order that he can make is he finds that the evidence is insufficient. Evidence is insufficient for that person to be tried in the High Court, so the magistrate can acquit that person in the magistrate's court itself. And that is done under section 153. So these two sections are also important, 153 and 154. Then under the Criminal Procedure Code, once the magistrate makes his order, he sends that order with the magistrate's court proceedings and the investigation notes to the Attorney General for him to consider charges. Sometimes the Attorney General might not agree with the magistrate's decision. And in that situation, the Attorney General has powers to override or to reverse the decision of the magistrate. So we must know the provisions which we have discussed at length with regard to the Attorney General's powers on reversing the decision of a magistrate. We must know under what section the committal made by a magistrate can be converted to a discharge. Magistrate thinks there is enough evidence, but the Attorney General, having a look at it, finds that there is not enough evidence against the accused. So Attorney General, then acting under section 396, will send an order to the magistrate saying, your committal of this accused to the High Court is quashed. It's quashed, and that person may be discharged. So that is given under 396. Then likewise, magistrate may have acquitted a person under 153. And the Attorney General is of the view, no, you shouldn't have acquitted that person because there is enough evidence for that person to be tried in the High Court. And in that situation, the Attorney General can send an order to the magistrate under section 399. So you must be aware of these sections also, because you can be questioned on under what section a discharge can be cancelled, under what section a committal can be cancelled by the Attorney General. Those are powers that are with the Attorney General, where the magistrate can't, he doesn't have a say when the Attorney General makes that decision. He has to just follow that order. Then in a High Court trial, another very important area is the area where at the end of the prosecution case, the High Court judge has to make a call on whether the prosecution has proven the case on a prima facie basis or whether there is any point in continuing this trial any further because the prosecution case is so weak. That is what is called the section 200 subsection 1 stage. This is a very important stage in a criminal trial because it states in section 200 subsection 1, the trial judge has to come to a conclusion whether the prosecution has a case against the accused which requires the accused to answer a case. If the trial judge comes to the conclusion that the prosecution has a very strong case which requires the accused to give an answer, then a defense is called from the accused. If the judge is of the view that there is not enough evidence in the prosecution case, the judge can at this 201 stage acquit the accused without continuing with the trial. So this is the very important area, section 200 subsection 1 of the procedure code, where the judge makes a decision and his decision is based on two factors. So you must know the two factors that the judge will look into. The first factor is if the prosecution's witnesses are wholly unreliable. If the prosecution's witnesses are wholly unreliable, then no judge is going to convict a person on a criminal charge based on unreliable or very weak witnesses' evidence. So he can, on that ground alone, acquit a person without calling for the defense. Accused has not even said a word during the course of the prosecution trial, and he would not be required to answer a charge because the prosecution has not established a case. The second ground being that an ingredient of the offense which needs to be proven by the prosecution has not been established by the prosecution. So that means the case has not been properly proven. For example, in a case of cheating, we all know for a person to be convicted, you have to prove that that person was deceived. Or in a case where dishonest intention is an essential requirement to be proven, and that dishonest intention has not been proven by the prosecution, then the defense is not required to give any explanation and he can be acquitted on that basis. So you must know the section 201 and the two bases on which the court can discharge or acquit an accused, you should know. Then of course, I told you I made 7 questions in this paper of 9 questions. Other 2 questions were done by DSD Miss Lakmini Girihagama. So she will discuss that at length, but I will briefly state that those 2 questions are on the grounds of, on the subjects of appeal, suspended sentences and conditional discharges. So with regard to those matters, you must listen to what she has to say about those matters. And with regard to suspended sentence, the definition of operational period. What is meant by operational period? You must know very well, because that is the period where the prison term is suspended from the date that it is imposed. And there is a statutory definition for that. So operational period, you must remember how the suspended sentences work, in what situations suspended sentences cannot be given, and factors like that. Then with regard to Attorney General's powers, you must, in addition to the powers that he has in non-summary inquiries, other powers of the Attorney General, like giving pardon to accomplices, nolle prosequi, then giving sanction to appeal, then also the powers of the Attorney General to summon any person. Any government servant can be summoned by the Attorney General for an interview. And that is under section 393 of the Procedure Code. So that kind of powers also of the Attorney General, you must have a brief knowledge and you should be able to cite the correct section under which the Attorney General gets his powers. Like now I told you that in the non-summary question, if a person has been discharged and the Attorney General is not in agreement, he is acting under section 399. So you have to give that particular section. In that answer as 399, if you give the answer as 393, that is a wrong answer, right? All of us know that there are powers. We know the nature of the powers, but if you don't know the section, that means you don't know the answer well enough. So we are not going to give marks for, half-boiled kind of answers, right? So those are the areas that I'm covering. And with regard to appeals, suspended sentences, and conditional discharges, Ms. Giriagama will speak to you before the exam. So in other words, what I'm saying is that the last two questions will be on conditional discharges, suspended sentences, and appeals. Because appeals we discussed rather at length, and last term in October, the question on appeals was not a difficult question, but it had many parts. But we found that a lot of students had avoided that question. The response to that question was very bad or not enough. But this time the questions that are formulated are more reasonable and many sections, but you have to once again be very accurate about stating the correct section, because if you state the wrong section, you are not going to get the marks. So I'll stop at that. Are there any questions that you want to ask me? Yes. No, the compulsory question is always with multiple areas. It's not like you can't break this procedure and separate it, right? Because we are not dealing with theoretical questions. We are dealing with a very practical subject, and the law college also requires us to ask practical subjects in an area like criminal procedure. So that is why actually making the paper is harder than you all think it is, because I have to decide on various situations and factors and all that. So I have given certain criterion or certain scenarios in the questions. And one particular scenario with regard to the compulsory question is applicable to the first four questions. The factual scenario given in for the first question is applicable until the fourth question. So that means there are going to be many aspects of criminal procedure questioned on the first scenario. Second scenario would be a scenario where there is unlawful assembly involved. So I have given you that clue as well now. Only one question would be of a theoretical nature where you can sort of by heart and state, but that is with regard to certain technical definitions. So that's not going to be easy question. But if you know the answer, it will be one of the quickest questions that you can deal with. Sorry? No. Now, as I told you at the beginning of the lecture, whatever I did not mention, like one of your colleagues have very correctly identified that I didn't say anything about jury trials or private planes. Both areas I covered in the last exam, and I thought I will not ask any questions on those lines this time. So jury trials and private planes, you don't have to know. But again, I forgot to mention one aspect. With regard to discharges and acquittals, you must know the difference between a discharge in the magistrate's court, and the acquittal. There is a definition for discharge in the Criminal Procedure Code, Section 2. So that is a important definition you have to know when it's a discharge and when it's an acquittal. With regard to acquittal, there is no definition, but acquittal means total exoneration from a charge. And when a person is exonerated from a charge, he cannot be charged again. We know the principle of doctrine of double jeopardy. Again, that doctrine of double jeopardy also I have not asked, I'm not asking a question this time. But the discharge and acquittal, you have to know the difference. Sorry? Section 201. Yeah, that is with regard to whether a defense is to be called or not. Yeah. Yeah. Yeah, so when a state has a right to file an appeal in that situation, then under the appeal procedure, there is provision for the state to file an appeal and ask for a retrial. Yes, retrial means before a fresh judge, but on the same indictment. Same indictment, fresh trial altogether. No, so when it's a fresh trial, you can call additional evidence also. If there is any evidence that was not called in the previous trial, can be called. Yeah, yes. Yeah, now with regard to arrest, when you're writing any answer, essentially what you need to say about a legal arrest is stated in 13.1 of the Article 13.1 and 23.1. I don't want you to go into even 23.2 with regard to using force. I know most of the law students want to go into that, but even if you don't write about 23.2 and 23 subsection 3, that means that you can cause the death of the person at the point of arrest. That all that detail need not be gone into, but the basic details of Article 13.1, 23 subsection 1 would be sufficient. Any other questions? So remember to write the sections, otherwise you're not going to get the marks, right? I have been telling you this. It's not the first day I'm telling. If anybody bothered to come and ask me, or bothered to follow even one of my lectures, those people would benefit who made that effort. Their time would not be wasted. Because most of the things that are there in the paper are matters that I discussed in class, which are not always discussed in my note that is given. So your private tutors will not know those things. Sorry? Litigation procedure. What is that? That has no application. There is no 523 in the procedure code. You are talking about civil procedure, I suppose. Now, don't write anything about civil procedure code or anything in my answers. I get very annoyed. I told you that, right? If you write even one section, I am not going to give marks. You can be sure of that. Don't write about the civil procedure code in the criminal procedure code paper. I'm sure the civil procedure lecturer will also say the same, right? We want to deal with people who know the law. When you become an attorney at law, it is presumed that you are a qualified professional. Otherwise, you will be a real fake, you know. So I don't want any of my students to be called a fake. They must know their stuff if they want to pass this exam and get into practice. And criminal procedure is a very important area if you want to work in a criminal court in this country. You can't work without the criminal procedure code. It's that important. Okay, I think all the online participants are aware of what I said today. So one of your colleagues here in the audience present with me is saying that you all may have questions, but when you had the option of coming here and asking me questions, if you decided to opt and expect me to answer your questions through online, I'm not going to do that. People who came here, bothered to come here at least today, I'm willing to answer any question that is here in the forum. But online people who chose not to do it for whatever reason, well, they have to go by what I say. And I'm sorry, I'm not going to take any questions from you. Number one, I won't have time. Number two, even though I like it, I don't think you deserve that option because you didn't bother to come today, right? So up to you how you fare, but on my part, I can guarantee you that what I have, I'm not going to ask you a single question outside what I discussed today. And subject to the areas that Ms. Giriagama will be speaking to you on, there won't be anything outside those areas, right? So all the best to you. I hope not to see any of you again in my class, but if you have the unfortunate situation where you have to come, I suggest at least next time come for my class, right? Okay, right. Thank you.